Now, Professor German, who is the Paralympic doctor, has been testifying, and he received an email from an external party who is also disabled, and she was describing how difficult it is being disabled and how she also has a heightened sense of fight or flight. Now, that email was rejected in court, and Judge Masipa said that it needed to be struck from the record. So could you explain the legal intricacies of what was happening there?
Well, I think the court found, and Judge Masipa made the decision, that this was basically hearsay evidence. So hearsay evidence in some instances can be allowed, but generally it is excluded. In other words, what somebody else has said or what they've written cannot just be handed up via another witness, as the defense have tried to do here. They should then have called the author of that email to come and testify. But in any event, is that so relevant? I think we can accept that people who have disability are at a disadvantage when there's an intruder in their home or about to break into their home. The whole issue of the emotional stress that one is under, I think all South Africans, you and I, are under that stress because of the high crime rate. And we probably all have friends or know of people who've been attacked in their homes by intruders. So, South Africans generally have this heightened awareness with regard to crime and people that can break into their homes. It might be so that Oscar and other people who have disabilities might feel it differently to, let's say, abled persons who don't have disabilities. For example, they can't run away as quickly, or they might have a heightened fear factor. Yes, but those are aspects that are relevant, but you can't present evidence by way of hearsay. You've got to present direct evidence. Somebody has witnessed an incident or has heard from the accused something, but if it's another party who's coming to say these are their experiences, that person must actually get into the witness box. And the reason really is quite simple. How do you test the reliability of that evidence? I think we've all seen how witnesses have come and might have said certain things. Many of the defense witnesses have come out saying things, and after cross-examination they've rather fallen apart. So that's why one has to be able to test their credibility, the reliability of their evidence. Where do they get to this conclusion in their evidence? And if that witness isn't in the witness stand, how do you test that aspect?
Right, because I suppose what confused us was Harry Nell got up and objected and said that while hearsay evidence is sometimes permitted in court, this type of hearsay evidence isn't allowed.
Yes. There are instances, and I don't think we need to go into a long legal debate, because, there's a law called the hearsay law. It's obviously described differently, but that in some instances, and there are requirements that are laid down, when hearsay evidence can be allowed, but not this. So generally speaking, what somebody tells somebody else, and that other person comes and says, hang on, Mr. So-and-so has told me all these things, I've got a letter from them saying these things, that is generally speaking not allowed. And that is why the court ruled in favor of Harry Nell's objection.